Good morning, everybody. My name is Richard Fink. I'm a lawyer who specializes in workers' compensation. This is the Injured Worker Side podcast regarding the Workplace Safety and Insurance Act. Today, we're discussing Bill 105, which is a government amendment to the Workplace Safety and Insurance Act that deals with three issues, which I'll describe in a minute. Today, we have with us Paul Taylor, my co-host, and Pamela Hughes Ford, my legal assistant, who will be addressing some of these issues. The three items addressed by the bill are one, age 65 is no longer a barrier to receive lost wages. Two, benefits will move from 85% to 90% of net. And three, the lock-in, which means workers after 6 years, whatever benefits they're getting from the WSIB for wage loss would be locked in. The locked-in will be removed. So I'll throw it over to Paul to introduce himself and talk about these three issues.
Hello, everyone. My name is Paul Taylor. I'm a licensed paralegal by the Law Society of Ontario with a specialization in workers' compensation and human rights law. If you want to reach out to either Richard or myself and be part of our podcast, you can contact us through the links below. So, just getting back to what Richard said, the three parts of Bill 105. First, before I do, I just want to give everybody a quick history lesson on workers' compensation law. And that is, and I'm going to do a very quick summary, and that is prior to 1885, or actually prior to 1915, when workers' compensation law came in Ontario, workers had to sue their employer. They would hire a lawyer like Richard and sue. And prior to 1885, it was less than 15% of injured workers were successful in the courts. An event happened, I believe it was in 1885 or 1884, where an ammunition plant blew up, killing 5 workers. The family of the 5 workers received nothing. The reason why is because employers claimed common law defenses, contributory negligence, assumption of risk, and fellow servant, meaning the employer would say, it's not my fault, it was the coworker, or the worker assumed the risk in the job, and so on and so forth. In 1885, the legislature, through considerable public pressure, was forced to create it says workmen's compensation, but it had nothing to do with compensating workers. It was more properly characterized as the Employers' Liability Act, removing those three common law defenses. What was observed was between that period and I believe it was 1900, that the number of successful claims for injured workers increased to 50%. However, in a letter from Professor Moore of the University of Toronto to the legislature, they said, yeah, it's great. 50% of workers are winning their cases, but 50% are not. And this is a key point because what happened is what that he was pointing out was those other 50% now become a financial burden to their family, their friends, but most importantly, society or taxpayers. Because when a worker doesn't have anything to cover them when they're injured, they can't work. And they then have to apply for social assistance, Ontario Works, Ontario Disability Support, and these other social programs that taxpayers pay. This is a key point that 99% of politicians and the courts ignore. They forget this key point. So at that time, in about 1910, the government, conservative government, appointed a conservative judge who was the Chief Justice Meredith, and he went around the world, he investigated, and he created a fair workers' compensation law. And he actually said a fair workers' compensation law provides for those workers financially so they do not become a financial burden to their family, their friends, or the taxpayers. That was basically what he said. And he had the 5 principles. I won't get into that. So from that time forward, the model at the time was one of the principles, which is key today, was one, that compensation shall be paid to the worker for as long as their disability lasts. It doesn't end at age 65. And it doesn't end if they can go back to work. They're compensated. Because, Richard, like I say, this is something that really bothers me with the law, the current workers' compensation law since 1990, is if I'm injured and I suffer pain, lack of mobility, I've suffered. According to the law, as long as I can go back to work, I get nothing. And that violates our Constitution. It violates our society's values on compensating those that have been injured. At any rate, prior to 1990, the model of the law was you got benefits for as long as your disability lasts. But in 1990, there was a huge and a historic change in the law. For whatever reason, they just said, we're not going to compensate workers for the rest of their life. And we're not going to compensate them this way. What we're going to do instead is we're going to turn off benefits at age 65. Instead, we'll give them a tiny bit of money for their retirement, and we'll pay them a little bit of money for their injury, pain and suffering as I call it, but only if the injury is permanent. Because we think those workers can work, and therefore why should employers have to pay them? As you can see, it's creating huge legal problems. The other thing that changed from 1990 prior and then 1990 was the way that they paid the benefits. Prior, they paid them 70% of gross earnings, which meant 30% was an approximate calculation of taxes. Post 1990, they said 90% of net earnings, right? Well, then in 1997, the Mike Harris conservative government reduced this to 85%, Richard. And I remember exactly what Mike Harris said. He said, we're going to reduce the benefits to 85% to encourage workers to get back to work. And the reason why I'll never forget it, because like, wait a minute, you have created this forced return to work policy in the law. So why are you now, it seems to be very contradictory. The real reason was he was trying to save employers money. He didn't care about the injured or compensating the individuals for their injuries. So then fast forward to today, and many advocates have successfully raised this issue with the legislature and saying, you know, you're given, I believe, and don't quote me on this, close to $10 billion back to employers through these austerity measures the WSIB has implemented. What about injured workers? They've given nothing to injured workers at all. So that's when I believe it was the Minister of Labor had said, okay, we're going to look at the age 65 issue. And ironically, after Bill 86 was dealt with in the legislature, where the government struck it completely down and didn't even discuss any of the critical points, where one of them was equal representation for employers and equal representation for injured workers on the board of directors at the WSIB. That was all voted out. So in response, the day before Bill 86 was to be passed, the government said, we're gonna increase benefits to 90%. I would like to correct them. It's not increase, it's restored to 90%. And we're going to deal with the age 65 issue. Where my concern lies is in the past, a worker, once they were getting their benefits for their injury, they were fine, it was secure, it was guaranteed. They didn't have to worry about deception or fraudulent games or whatever you want to call it, right? They were secure in that. After this now, the board or the staff, as you noticed, I believe there was many advocates who looked at appeals from the WSIB to the tribunal, and it was something in the neighborhood of more than 70% were overturned. This takes a year to 2 to 3 years to go through this appeal process. And now I'm noticing even longer. These people have to go without any source of income. Oftentimes they have to go to social assistance programs like Ontario Works, Welfare, and ODSP to provide for them because the system is so delayed. As a result, this concern with the lock-in, so three of the changes, as Richard mentioned, was the age 65. My concern with the age 65, it is not like if you were 55 or 50, you get benefits, you're guaranteed, you prove your injury, you're done. At age 65, you have to make the request. If you don't make the request as an injured worker, you get nothing. Also, this is the part I love, the board decides if you could have worked if you weren't injured. But there's no, which angers me, they don't have to, when they're making this decision, base it on, how would I say, the rule of law, meaning evidence, medical evidence, things like this, or anything. They can just say, I don't like you, so I'm going to say no. This is a term, what I've created, or I don't care, anybody can use it, reverse deeming. Because prior to age 65, the board would often say to injured workers, well, Pamela, I think you can work, so therefore you can, and I'm going to deny benefits. Now we have the reverse happening, where when you turn 65, they're going to say, well, we think you could have worked, so we're not going to pay you benefits past age 65. So it's really, as far as I'm concerned, nothing but political fluff. It is not real, the age 65 standard. The other one is the 90% benefits that I want to quickly talk about. And as I was saying to Richard prior, is if you don't compensate somebody 100% for their injury, then in my opinion, you're punishing them. You're saying, I think you're 10% responsible or 15% responsible. And to me, that is punishing them that you've admitted it's the injury is accepted and everything. To me, it is a classic case of a charter violation by not paying the worker 100% of their benefits. So that's the one thing. It shouldn't be 90%, it should be 100%. And I also think that the whole model should be redone because, as I said before, if you don't compensate the worker for their injuries specifically, not the loss of earnings, the injury, meaning the pain, the suffering, the lack of mobility, right? They don't compensate. Often I hear workers saying, Paul, I got to shovel my driveway and cut the grass. I can't do any of that stuff. And the board won't pay somebody to do it for me. What do I do? Like you're on your own. But ironically, Pamela, if the worker does shovel the driveway, the board sits there, suspends the benefits, then accuses them of fraud, and then prosecutes them. And this is something that I'm going to get into next with the 72-month lock-in period. The constant fear on the part of injured workers, which is a genuine fear that they're going to be persecuted by the board, that the board, they could have benefits for 20, 30 years, and then all of a sudden the board goes, they get some weird case manager or some new hidden policy where they go, cut all benefits. So now there is no lock-in, there is no guarantee, and they're going to suspend your benefits. Myself and probably at least 10 other injured workers I talked to, where the law says we have a right to health care benefits for maintenance. This is accepted. The board repeatedly denies it. I have yet to even in myself get prescription benefits restored, even though the WSIB appeal says, no, we don't do that anymore. You're supposed to get full health care. So in the government saying we're going to remove this 72-month lock-in, this is what happens is prior to 1997, injured workers that were permanently injured and were receiving a monthly amount of money, after 60 months, it was locked in till age 65. So they didn't have to worry about the board playing games and suspending it or cutting it or anything. It was secure. In their mind, they didn't have to worry. Then in 1997, they changed it from 60 months to 72. They added a year, made the worker wait even longer. But even after waiting the 72 months, you knew that on the 73rd month, once it's locked in, you don't have to worry about the board changing it for any reason. Now they want to remove this, and that is going to create constant fear and panic with injured workers. The board and the legislature will say, oh, that's ridiculous. There's actually currently, Richard, there's a study at university looking at the actual impacts, the mental, the psychological impact the administration of workers' compensation system is having on injured workers. So this is my spin on those three issues.
I just want to make a couple comments. So going to the first thing with the benefits past age 65 or beyond the 2-year mark if you're 63 or older. We don't know what this looks like in terms of the criteria. So we don't know what information has to be provided to the WSIB. Like Paul said, we have issues right now with decisions not being rendered properly. So this is going to bring up a ton more appeals into the appeal system, into WSIA. There's going to be more backlogs. I'm sure that the WSIB is not going to tell people that they have to apply for this and ask for this. We also don't think that this is going to be retroactively applied to anybody. In other words, people who have already hit age 65, it will not likely be eligible for this. This is the problem with Bill 105 is we don't know the specifics yet as to what the criteria is going to be, what the effective dates are going to be. Is it going to be applied retroactively? The main issue and the main concern I think I see is the lock-in decision. So right now, as Paul was saying, your benefits get locked in at 6 years from the date of your accident, or they can extend it up to 8 years if the person is involved in approved medical treatment and retraining. However, if somebody asks for a NEL redetermination after their LOE lock-in, that opens the window for 2 years from the date of the NEL redetermination for the WSIB to go back and revisit that lock-in, which means that there is a possibility under Bill 105 that if somebody is locked in right now and they ask for a NEL redetermination, and that 2 year window opens for the lock-in, and then Bill 105 comes into play, they could have their lock-in completely removed because we don't know the specifics on that. So that's a major concern. It's also concerning in general that the WSIB kind of uses it as a, I don't know if I want to go as far as to say like it's a tactic basically that if you want to say, oh, I don't think that this is correct, I think my condition has worsened, or I don't think you calculated my NEL correctly, these injured workers have this severe fear of, oh my gosh, I don't even want to try doing that because I'm locked in and it could affect my lock-in. So again, the fear that injured workers have because of the way that the WSIB has treated them, what's happened to them over the course of from the date of accident ongoing, and all of these financial stressors and everything else is a very big deal. And by having Bill 105 remove the lock-in, it's very, very concerning going forward how it's going to affect everybody.
Let me say Harry Goslin, which is the head of the union at the WSIB, said uh, the lock-in removal is going to be the most difficult issue for his coworkers to deal with. Uh, does this mean that every injured worker who's receiving LOE benefits must send in a tax return every year so the
Well,
WSIB can see if their earnings have gone up?
that's
So
what I think is going to happen.
the lock-in removal is going to be, I believe, retroactive. So it's not just for injured workers who are injured as of the day the legislation starts, but it applies to all injured workers who haven't yet hit their lock-in. Or perhaps it'll be all injured workers who are receiving WSIB. Does that mean there's going to be hundreds of thousands of people who have to send in their tax returns practically indefinitely, or at least to age 65 for previous injured workers and new injured workers until the day they die? Is WSIB going to have an AI computer searching what they're paying and what the worker's receiving from any sources? Uh, the problem with this legislation, in part, beyond the fact that it's grossly unfair, is there's no indication from the labor minister how they're going to do all this.
Yeah, that's the major. Yeah, sorry, just let me just say one thing. That's one of the concerning things is that they throw these things out. They've already gone through the first reading. This could be happening as early as next week, is what we've been told. And we don't have the specifics, which is the major problem. So, I mean, there is the potential where they said the WSIB will be allowed to review earnings and request medical information based on whatever period of time they see fit, but they have not specified what period of time that is. So if the government doesn't specify like it's an annual review, then the WSIB essentially could do whatever they want, whenever they want. And what I fear is that this will be a situation where it's like, oh, this person's been on benefits. They potentially could have them followed to see what's going on because they're making a lot of money. They're going to be pressing for, hey, you need to go for this medical treatment. And if you don't want to go, we can suspend your benefits. There's going to be problems as long as the claim lasts instead of up until the lock-in. So it's going to be major problems, and we don't have the specifics.
Yeah, I just wanted to add about the this lock-in and not lock-in. And you had mentioned too that you would be required or the board would reduce your income based on 100% of pre-injury net average earnings. So in other words, You could be making, say, $5,000 a week, and then say just before your accident, you have a vacation, and the board goes, well, we don't look at it, or you take time off for whatever reason, maternity leave, whatever, and the board can look at it in theory. I'm not saying they do, I'm just saying possibly, and drop your net average earnings. I have seen many times where employers will literally fudge the numbers on income reporting because when I get an injured worker come to me, one of the things I look at is the employer's report of injury. I'll say, is that the injuries? Is this your reported income? Is this your net exemption code? And this is something most injured workers don't realize how important it is that, as I was saying, is we're talking about net earnings. The law says you're to be paid 90% or 85% of your net earnings. Now, when the employer reports it to the board, they report your gross earnings, meaning before taxes. But they also tell the board your net exemption code. So if a worker says to the employer or doesn't report it, and the employer just tells the board it's a single person, meaning I think it's net exemption code 0 or whatever, that means then that the board will pay you benefits based on a single person, which means you'll get this much, as opposed to, say, somebody with 4 kids and being single, which would be this much, simply put. So you're actually getting screwed on what you should be actually entitled to. So what really concerns me, getting back to my point, is this word average earnings. It's not actual. Now, I mean, I can see the board saying that, well, if your income is fluctuating, then we'll take the average. But if you make the same amount all the time, I just don't like the wording because I've had very bad experience with the board in dealing with them.
The age 65 issue, we went to court, our law firm went to court a few times to fight the ban on age 65. At that time, 9% of workers were working full time past age 65. That's now gone up to 30%. The case that I had, the worker said, my brother works at a factory. He said I could get a job at the factory. When I was over 65, there was a job waiting for me when I retired from my current employer. And I was prepared and fully able before my work injury to go work at the factory where my brother was. And of course, we lost that case. But the problem with the new law is, would we get past age 65 benefits under the new law? He doesn't have a contract with the new factory. He hasn't yet worked at the new factory. What are going to be the criteria to actually get benefits past age 65? You'd think the statute itself would have some of the basic criteria. Instead, they're going to leave it to the WSIAB, and their modus operandi for the past 15 years has been, let's have regulations as constricting on workers' entitlement as possible. So it sounds great. Workers now will be paid past age 65. The ones that could be paid are only probably the ones that are in a company where they don't have absolutely no regulation on terminating workers after age 65. And most of the workers aren't in a company that has regulations one way or the other. So there's absolutely no idea how this is going to play out. The other problem is that, let's say you move to Italy after your work injury. Are you going to have to file your tax returns from Italy every year so the WSIB can determine whether you're making more money in Italy than they have you deemed for in Canada?
Richard, you can't, even if I'm only speaking about Canadian citizens, not permanent residents or work visas. I'm only speaking about Canadian citizens in reference to Section 6 of the Charter. According to WSIB policy, I can't pull it up right now, and there's no point. It says that an injured worker must or cannot leave Ontario without the express consent, written consent, I assume, of the WSIB. If they do, the board can reduce or suspend their benefits and prosecute them in provincial offenses court.
So if 8 years after your accident, you go and move in with your family in Italy, you're screwed?
Theoretically, yeah, they could try and prosecute you, but then, like I say, it's a blatant violation of Section 6 of the Charter, right? Where any injured worker that's happened to, like injured workers often will travel to well, probably not right now, they'll travel to the States, for a holiday, for a weekend or whatever. No big deal. But if the case manager, if the board, I'm not saying case manager, but if the board wanted to be nasty, they could do that. They have that legal authority in the policy. Like my thought right off the top of my head is whoever wrote that policy is a complete moron. Because one, it applies to all injured workers regardless of injury date. And I go back to my previous comments with you, Richard, which is the board cannot legally make a policy to interpret another law, meaning the Workers' Compensation Act of 1990 or 89 or whatever, and they're doing it all the time, right? And that's section 159 of the act. So if they said to me this policy, that's one argument I would make, that policy does not apply to me because I was injured prior to 97. If I wasn't, and the policy applies to me in the sense of year of accident, then I would argue it's a charter violation. And I doubt very much any judge would sit there and go, yeah, the board can do whatever it wants. Because the Court of Appeal did get really nasty with the WSIB when they were getting stupid with these prosecutions of injured workers. They had no medical evidence of any one of the three injured workers that were there. They just said, we think you're faking. And they prosecuted them. One or two they did, and one they lost. But that one they were appealing and were trying to reverse the conviction. And the judge said, basically, isn't enough you took their benefits away, now you want to throw them in jail? And I think it goes to this point that Steve Mantis, an advocate for injured workers for decades, had said, there's a huge issue with stigma that everybody seems to think that all injured workers are faking. But you can't look at somebody and say, I think you're faking without any evidence. And that gets to the bigger problem where I look at decisions like Fiera, where the tribunal panel members literally said, we think he's faking, so we're going to ignore all this medical evidence and put our own opinion that we think he's faking in place and deny the claim. To which the divisional court said, yeah, you're not a doctor, you can't do that. So I say to the court and to everyone, okay, great. In that case, he got his benefits restored. But what about that harm that decision caused that individual injured worker? What about it when the case manager or the appeals officer, or as we often know, it really is covert policies at the board where it causes harm to the individuals? We know the harm is genuine and real because there is research studies confirming this. But legally, the courts seem to be completely blind to this right now, where they're like, just go through the administrative appeal process, get your benefits, and be happy. But when it's an institutional bad faith thing, it concerns me, and it gets back to the subject that we're talking about, that can we really, as injured workers, trust the board to do this fairly? My question is there was never a lock-in prior to 1990. For almost 100 years, injured workers received full benefits for their injury for as long as their disability lasts. Then the government changed it. So for 30 or 40 years, 36 years, the government was happy with having a lock-in. Now all of a sudden they're saying no, but they're not explaining why they want to remove this lock-in. And I can only guess because the number one reason in the act, which is fiscal responsibility. They want to steal from people that are injured to give to rich corporations. That's just my opinion. But that's what it seems like this legislature's about.
Let me just conclude with one case that I worked on yesterday with the injured worker to illustrate the nightmare. So the worker is injured by a blast of fire, and his face is severely burned. And after a few months, he goes back to work, but the employer demotes him from his job as a major supervisor to somebody who goes around with a cart and picks things up. And after a few months of that, the injured worker quits that job and he gets another job as a truck driver, which is a long way from being a supervisor at an industrial plant. And then he starts school on his own to upgrade himself so that he can go and find some other type of job that stays away from sunlight because his face is still severely burned and he gets laser treatment every 3 months to try and correct the fact that his skin is falling off his face.
Clearly, as you always say, Richard, and as I say my phrase, you never shut up about, which tells me you're very passionate about it, and you're right, is the point that you're saying that the board isn't taking care of injured workers, and in this case, they're not at all.
So
But the other,
let me just continue for a
oh,
second.
sorry, I
So
thought you finished.
the WSIB doesn't pay him. So his injury is 2016. And he's supposed to be locked in if they decide to pay him at 2022. His accident was in June of 2016. In May of 2022, they speak to him and they say, "What have you been doing these last few years?" And he says, "I've been at school." And then sometime in September, October, they start to plan that will get you tested and see what kind of job and education you need. And the WSIB has to get him into a return to work plan. This is the legislation, the actual law. The law says you have to be in a plan before the 6 years expires, or else you're locked in. The WSIB's position is, we spoke to you in May about what you're doing. That's a plan. You're in a plan. You're part of the system. The regulations that the board has passed, their policy says when you're actually doing something about the plan, that's enough. So the board says when we spoke to them, we were doing something about a plan. They didn't have a plan. They didn't discuss a plan. They just said, "What are you doing?" And he says, "I'm at school." They said, "Oh, that's a plan that we've started." And
But he
now,
was doing the school on his own.
yes, so that's a
And no, that's
plan.
not
That's
the
the
WSIB
board
program.
says that's our return to work plan. Then he goes to school for another 2 years. He's not making any progress. He drops out and the board cuts his benefits by 3/4. So we're now in 2026. He's going to have a hearing at the ARO on whether A, he should have been locked in, and B, whether he's mentally and physically able to go and make $20 an hour, which is what the WSIB says. $20 an hour at 40 hours a week. His psychiatrist says he's barely able to get out of the house, let alone starting to work somewhere and concentrate for 40 hours a week. This case will go on for at least another 2 years. So he's going to be spending almost 20% of his life fighting with the WSIB. And I raise this as an issue because if you extend the lock-in forever, injured people who are injured, who have serious disabilities, are going to be fighting with the WSIB till their dying day. And it's really a very pathetic and bad situation. So maybe we'll leave it there and we can conjoin next week and perhaps raise all this again. Thank you.
Thank you. Take care.
Thanks, everyone.